Hi, good evening. It's a Delhi High Court judgment. Citation is SpiceJet Limited versus Union of India. Issues are one, foreign employees working in Indian establishment and domestic employees are also working in Indian establishment. Both are mandated to contribute Provident to the Provident Fund scheme. But Indian employees who pay draw up to rupees 15,000, that is less than rupees 15,000 per month, they are mandated to contribute. But foreign employees, they are mandated to contribute irrespective of their pay received by them. So, the question before the Delhi High Court was whether this classification is a valid classification under Article 14 of the Constitution of India. The second issue was the notification read with the scheme, Provident Fund scheme, permits withdrawal of the PF amount standing to the credit of the foreign employee only after retirement from service. That is, after he attains the age of 58 years. Even though the foreign employee, he may serve the establishment, Indian establishment, only for some 2 to 5 years maximum. Whether this notification or the notifications are arbitrary and unreasonable. So these are the two issues. So naturally, the judgment is on Provident Fund contribution by foreign employees. Facts I don't have to state because these are the facts. Already you would have guessed some foreign employee is coming, serving Indian establishment, and he is liable to contribute for the Provident Fund. So that is the fact. According to me, in that entire judgment, two definitions are important. One is international worker, and the other is excluded employee. These two are very important. International worker is of two types. First type, Indian employee who has worked or working in a foreign country with which India has entered into a social security arrangement and is eligible to avail the benefits under a social security program of that country. So, Indian employee, he goes from India to the foreign country. He works in that establishment. There is an arrangement. India has entered into a social security arrangement, and that Indian employee is contributing to the social security arrangement in that country. That is one. Second is an employee other than Indian employee holding other than an Indian passport. So your passport must not be an Indian passport. Working for an establishment in India to which this act applies, the Provident Fund Act applies. So these are the two types. First type is Indian going there. Second type is foreign employee coming here and working here. Then excluded employee. Who are the excluded persons? An international worker who is contributing to social security program of his country with whom India has entered into social security arrangement on reciprocal basis and is enjoying the status of a detached worker for the period and terms are specified in the social security. So he is an international worker contributing to social security program of his country and only treated as a detached worker for some time. And India has got an arrangement between them, reciprocal basis. Then the second type, an international worker who is contributing to a social security scheme with whom India has entered into a bilateral comprehensive economic agreement containing a clause on social security prior to 1/10/2008, which exempts natural persons of either country to contribute to the social security fund of the host country. So he goes there, he or the foreign worker comes here. India has got a bilateral agreement, so it contains a clause it exempts a person to contribute to the social security, PF, because you will be contributing there, you need not have to contribute here. So that is the point. So these two are excluded. So now you know who is an international worker, you know who is excluded from the Provident Fund scheme. Then writ petition is filed on the issue of employees who are of foreign origin with whom India does not have a social security arrangement on reciprocal basis. That is important. So if you have a reciprocal basis arrangement, then you need not have to contribute. Now the issue is the foreign country is not having a social security arrangement on reciprocal basis, or with whom India has not entered into a bilateral comprehensive economic agreement. That is also not there. So whether the classification is valid, whether the notifications are arbitrary or unreasonable. Because classification is, if you are not having a social security arrangement on a reciprocal basis or bilateral economic agreement, then even though you may be contributing in the host country, if you come and work in India, you have to contribute again, irrespective of your salary. So that is the point. So the scheme permits international workers. The another point which again I am stressing is the scheme, Indian scheme, Provident Fund scheme permits the international workers to withdraw the full amount standing to their credit in the fund only on retirement from service in the establishment after attainment of 58 years of age. So that is also important. Or on retirement on account of permanent or total incapacity for work due to bodily or mental infirmity. So is this arbitrary or not? Because I contribute here, but I can withdraw it only after I attain the age of 58 years or because of total disability. Is this fair? That is the point. That is the issue raised before the court. Delhi High Court relied on Supreme Court judgments, laying down the following principles as far as classification is concerned. So the first principle of equality does not mean that every law must have universal application for all persons who are not in the same position by nature, attainment, or circumstance. So universally, the law need not be universal to all. Point number one. Two, every classification in some degree is likely to produce some inequality. But mere inequality is not enough. And that Article 14 of Constitution of India can be said to be violated only if equal protection is denied to two persons belonging to the same class or category. Again, extension of the same thing. Universal application need not be necessary unless it violates between the same class or category. Third, for a classification to be valid, two conditions must be satisfied. What are the two conditions? One, classification is founded on an intelligible differential. Differentiation between the class must be on intelligible basis. Two, differential must have a rational nexus to the objects are to be achieved. Are you achieving the object? That is why you are classifying between two persons. For example, income tax. Income tax below a certain category, you need not pay. Above certain category, you have to pay. Classification is valid because both are two different classes. One is not able to meet their monthly needs, so they are exempted. One is rich, or even though you can say even if you earn 12 lakh and 1 rupee, you will be liable to pay income tax. So some classification is necessary. That is okay. The object is also okay. To achieve the object, you are taxing people. That is also okay. For an example, I am giving this. So now, Delhi High Court accepted the argument of Union of India that mandating the foreign employees to become member of the scheme or the fund, irrespective of the monthly pay they draw, and requiring only those Indian employees to become member of the fund or scheme who are drawing pay below rupees 15,000 per month, it has a rational basis because of the economic duress which is caused to the Indian employees. So court mainly says because of economic duress. Indian employees who are drawing less than 15,000 are mandated and not the foreign employees. Irrespective of their salary, they have to become the member of the fund. In case all the Indian employees, irrespective of the amount of pay they draw per month, are mandated to become the member of the scheme, they will be subjected to harsh economic duress for the reason they will be required to contribute to the scheme for fund throughout their period of employment, which generally will be much large. Because you join at the age of 25, 26, then you will be retiring at 58. All throughout your lifetime, you have to pay, as compared to the length of employment of foreign employees in an Indian establishment, which normally is 2 to 5 years. The reason, simply put, the reason given by the High Court, canvassed by Union of India and accepted by the High Court, is economic duress. Indian employees who are drawing less than 15,000, they are mandated to contribute. Foreign employees, even there are 2 to 5 years they are working, they are mandated to contribute because foreign employees, they do not have economic duress. Indian employees have economic duress. That is the point. The court accepted it. On the above basis, the court said the classification is valid. These are Indian employee, foreign employee classification is valid. Simply put. With regard to the scheme being arbitrary and unreasonable, because it allows the foreign employee to withdraw the amount after attaining the age of 58 years, court said it has been brought to implement India's international treaty obligations. And entering into an international treaty is a foreign prerogative. It is a sovereign prerogative. That is, India has got the right to enter into any international obligation that the court cannot interfere. Therefore, if such a provision is struck down, that will amount to taking away the legal basis for entering into and applying the social security scheme. Hence, on this ground, that submission was also repelled. I want to put my comments on record. I really do not understand. I don't understand. Employees who is drawing, employees who are drawing less than rupees 15,000, they are mandated to become member of the PF scheme. And it is not mandatory for the employees who draw more than 15,000. I agree. But what is rupees 15,000 today? If that, from that 15,000 rupees, if you deduct 10% towards PF contribution, the person will receive only 13,500 per month. The employer will also be contributing 10%. Leave that. But will he not suffer economic duress at present? That is the question I am asking. A person who is drawing less than 15,000, if he is forced to contribute 10% towards the PF, then will he not suffer economic duress now? Then when he gets that amount after 28 years, 30 years, at the age of 30 he is joining, 58 is coming out. The money you are giving due to inflation, again it will be, the value is very, money value every day if you see, money value is less. Earlier with 2,000 rupees I used to buy provisions for the entire family. Now if you go with 6,000, 7,000 rupees, the provisions are not much, but the cost has increased so much. So economic duress, while living also he is suffering. While at the time of retirement also he is suffering. So what is this economic duress? I don't understand. Then second point, is it not a social security measure that they get lump sum after retirement? How it becomes harsh economic duress for employees who earn more than 15,000 and not for those who earn less than 15,000. Why I am saying this is, court says if all the employees, Indian employees are mandated, they will suffer harsh economic duress as they have to contribute for a longer period. I don't understand. A man who is earning more than 15,000 rupees, if he is mandated to contribute, how he will suffer? How it will be a harsh economic duress for him? That I don't understand. The third one is, Delhi High Court did not answer the question why an international worker should wait for 30 years or 35 years to get his contribution to the Provident Fund. Suppose there is no social security arrangement or bilateral arrangement with India. He comes and works here for 2 years or 3 years. At the age of 25, he contributes. He complies with the law. Why at all he should wait for 33, 35 years? I don't understand. You may say treaty, etc., etc., but it looks unreasonable. A person who contributes at his young age, why should he wait till 58 years? I don't understand why he must wait for 30 to 35 years to get that money back. I think really I don't understand, and the reasoning given is not enough according to me. Third, the fourth point, this writ petition was filed in 2012 and judgment comes only at 2025. So the foreign worker has to wait only 3 times of the judgment period. So time flies. So if he is lucky, he will get it. That is what I feel. Thank you very much. Have a great evening. Bye.